Hello everyone, my name is Hania and I am a fourth year law student at St. Joseph's College of Law, and today we will be talking about environmental law. This isn't merely a legal topic, it is one that sits at the very core of our survival, sustainability, and the rights of future generations. Law and society are deeply interconnected. Sometimes societal movements have led to statutes being drafted and enacted, and sometimes legislation has led to society changing. They have led to society reforming, which would have otherwise been considered a normal practice. Under the environmental law umbrella, we can see both. One of the first societal movements to impact environmental law legislation in India was the Chipko movement. And this movement was in the 1970s and saw people in the rural areas of Uttarakhand, especially a village called Raini. And it saw women from these villages coming out to defend their trees and land from deforestation. This started what we can term as an eco-feminist wave in India, the first of its kind. In the south of the subcontinent, around the same time, we have the Silent Valley movement. This was triggered by an announcement made by the Kerala State Electricity Board, the KSEB, which proposed a hydroelectric project that would have flooded a very significant portion of the Silent Valley, which is a region rich in biodiversity and home to many endangered species. The Kerala Shastra Sahitya Parishad, the KSSP, which is a very well-known organization, put sustained pressure on them over a lot of time, and this led to abandonment of the project. These forces, or if you will, people voicing out, standing up, and making sustainable efforts are extremely important. This is what motivates legislators and judiciary to take action. This is exactly what happened here. In the 1970s and 80s, we saw a slew of legislations being enacted for environmental law protection. We should remember that environmental protection doesn't start and end with forests and their conservation. While it is an important step to truly conserve the environment and make an impact, the efforts must come from all directions. We see the Indian legislature taking significant strides to protect our national heritage through landmark statutes such as the Wildlife Protection Act of 1972, the Forest Conservation Act of 1980, the Environmental Protection Act of 1986, the Water Prevention and Control of Pollution Act 1974, and so many more. These legislative efforts were not only a response to people's movements, but were also deeply inspired by the vision laid out in our Constitution. In fact, the Supreme Court of India has played a vital role in advancing this vision by interpreting Article 21, the fundamental right to life, to include the right to a healthy environment and a right to be free from the adverse effects of climate change, as held in the MC Mehta versus Union of India and Ranjit Singh versus Union of India in 2024. Several international conferences have significantly influenced the development of environmental law in India as well, and these have shaped the national policies and legal frameworks. This includes the 1972 United Nations Conference on Human Environment, which was a pivotal moment that led India to incorporate environmental protection into its national agenda, which culminated in the 42nd Amendment to the Constitution in 1976, which introduced two articles, Article 48A and 51A Clause G. So Article 48A is a DPSP, which directs the state to protect and improve the environment and to safeguard the forests and wildlife of the country. And of course, 51A Clause G, which places a fundamental duty on every citizen of India to protect and improve the natural environment, which includes forests, lakes, rivers, wildlife. The scope is huge. In 1992 Earth Summit in Rio de Janeiro, this further enforced India's commitment by promoting principles of sustainable development, the precautionary approach, which have since been reflected in judicial decisions very actively, and even national legislation such as the EPA of 1986. Additionally, conferences like the 2002 Johannesburg Summit and the 2015 Paris Agreement under the UNFCCC have influenced India's climate change policies and led to the formulation of the National Action Plan on Climate Change, the NAPCC, and various other state-level initiatives. These global events have collectively encouraged India to progressively align its environmental laws with international standards and sustainable development goals. We have the judiciary playing a very important role not only by interpreting Article 21 as we see in the MC Mehta case, which was a case followed the hazardous gas leak from Shriram Food and Fertilizer Limited in Delhi. This case was filed for the compensation to victims. It led to discussions under the Factories Act of 1948, the EP of 1986, which was enacted shortly after the Bhopal gas tragedy. The Supreme Court introduced the principle of absolute liability for industries involved in hazardous activities. This is stricter than strict liability because no exceptions are allowed. 2 years later, we had the Ganga pollution case, and this case was concerned with the discharge of untreated industrial effluents into the Ganga River. The court ordered the closure of these polluting tanneries and emphasized the polluter pays principle. More recently, we've seen in the T. and Godavarman Tirumulpad versus Union of India, the forest case series, which was ongoing from 1995. This started with deforestation in the Nilgiris and later expanded to forest conservation nationwide. And this looked into the Forest Conservation Act of 1980. The Supreme Court held forests can be interpreted pretty broadly, which imposed a ban on tree felling without clearance, directed the formation of the Central Empowered Committee, the CEC. In conclusion, the evolution of environmental law in India is deeply rooted in a series of landmark judicial decisions that have transformed environmental governance from a policy aspiration into an enforceable legal mandate. The judiciary has played a pivotal role in interpreting these constitutional provisions as well, especially Article 21, which is so fundamental because it guarantees the right to life, and now we can say it guarantees the right to a clean and healthy environment. The Supreme Court established using multiple cases the foundational principles of absolute liability, polluter pays, and precautionary action, thereby reshaping how industries and authorities approach ecological responsibility. Each of these cases not only addressed the immediate environmental harm, but also laid down enduring legal doctrines that continue to guide regulatory authorities and lawmakers, whether it was holding municipalities accountable in Ratlam, or regulating forest use in Godavarman, or curbing pollution in Vellore. The courts have persistently emphasized that economic development must not come at the cost of environmental degradation. After all, what would we have left then? Acts like the EP of 1986 and the Forest Conservation Act of 1980 have been interpreted not as mere administrative tools, but as powerful legal instruments to secure intergenerational equity and sustainability. These judicial interventions underscore a broader truth. Environmental protection is not just a government function, it is a collective civic duty that we all have. As we face modern environmental challenges such as climate change, air pollution, water scarcity, these precedents remind us that law must evolve to meet emerging threats and that vigilant citizens, empowered courts, and responsive governments must work in tandem to uphold the delicate balance between development and conservation. Let us then not view environmental law as merely just a set of rules, but as a living commitment to safeguard our planet for the generations to come. Thank you for watching us, and for more such videos, please subscribe to our YouTube channel.